Todd, you might could use your. Should I go ahead and do
Here
roll
comes
call?
something. Here comes something.
So I'll do roll call. Chris Perry, Scotts Valley Water District.
We got it now.
There we go. All right, so we're going to do roll call in a minute. I just want to make a couple of points. So welcome to all of you that are here from the MGA, from other water districts, and it's great to have a reason to come together. We all need to have this ethics training, and Bob, thank you for doing that. We are going to, the schedule is that between now and a little before 7, there will be the ethics training, and then there will be a closed session for the water district, and then there will be the regular meeting at 7:45. This session is just essentially for the people that came for the training, so there's not going to be really a public comment or question period. Questions and comments will come from the people that are participating in it. There will be a public comment period during the regular meeting that starts at 7:45. Okay, so now we'll do roll call for the ethics training.
Yeah, and I'm sure most of us know each other, but if you could raise your hand just so everybody could get a take when I call your name, I'd be appreciated. Chris Perry, Scotts Valley. I don't see him here. Okay, we'll make note if he comes in. Robert Schultz. Ralph, thank you. All right. Ralph Bracamani, Central. Thank you. John Rickard, County. Tim Carson, Community Foundation. Great. Laura Arch, Community Foundation. Kurt Abramson. Okay, thank you. Jim Kerr, yep, right front. John Kennedy, deciding. Ed Harmon from Fire District. Right, only fire person. Thank you. Okay, Bill Eckwall, right here in front. And Dr. LeHue.
I'm here.
Dr. Daniels. Dr. Jaffe, no, not yet. Carla Christensen. Rochelle Lather, here, okay. And the rest I can vouch for. Ron, Emma, Christine, Tracy, Shelley. Well, no, not Shelley. Melanie, Leslie, and Josh.
Okay. All right, take it away.
Sure. So this is the biannual, every 2 years, ethics training that's required of public officials and managers. And the presentation I'm giving is one that's given by the ACWA Legal Affairs Committee, of which I'm a member. And they've prepared it, and I'm supposed to acknowledge that, and I just did. Somehow we are moving too fast here. Why?
You know what, we probably got it on the...
It's all right, it's right now. I backed it up.
Okay.
Yeah. So this is, why are we doing it? State law requires it to receive it every 2 hours of ethics training every 2 years. We're going to focus on ethic principles and substantive areas of laws that actually apply to ethics. And I want you to understand that this is really a brief overview. It's certainly not going to give you the detail you need to understand each of these areas. And if you have those kinds of questions or you think there's a question, please consult your local agency counsel. Never assume you know the answer. It's always better if you're not sure to find out, because finding out later you're wrong can have serious consequences. So I'm trying to familiarize you with ethic laws and principles that govern your service. I want you to think beyond the legal restrictions and discuss general ethical principles to promote public trust in government and, of course, meet the statutory training requirement. I can't stress enough how important it is to think beyond the law, because the law is only what's required, and it's not the perception that is necessary. That if you want to have the right perception to the public, as public people who are working in the public service, you want to make sure that it looks good in addition to being good. So the law is the floor for ethical conduct, not the ceiling. Okay. So
Bob, are
yes.
you scrolling through slides? Because they're not.
They're not doing it. So
let's see if we're...
that's not connected to
Try
it,
to-
folks.
Here, let's see. That's what I was saying.
Because you said they're going fast and they're going super slow for us.
I'm sorry, I was looking here and not there. All right.
All right, hang on, we're not there.
Are you guys doing
yet.
ethics
This is
training?
on. Where are we?
You're not doing, yeah, we're auditing, so
I'm sorry where this is coming from. Dr. Jaffe just came in. Okay, great. We'll look at our office.
All right.
I still don't understand why we don't have this in Hawaii.
So,
It's not showing, it's not.
Do I have to use that?
I'm gonna have to call you back, sir.
Okay, there it goes.
something happened.
Yeah, let's see if it works this way.
It's here.
Try that.
Yeah, make yourself comfortable. I'm just gonna be here to film. This will be up on YouTube.
Yep, we're good. All right, so we already did this part. So, these are the four principles that we're going to be talking about in general tonight. Trustworthy, thus fairness, responsibilities, and respect. Those are kind of the four areas. So the first one is conducting the public business opening, the Brown Act. The Brown Act actually was adopted probably 40 years ago, and it had nothing to do with either Pat Brown or Jerry Brown. It was a legislator by the name of Harold Brown. It had something like 658 words when it began. It's into the thousands now. It's constantly modified. But the basic principle is still what's set forth in 5490, and that is the people have a right to know what's going on in meetings, and all meetings of a legislative body or local agency should be open to the public with certain exceptions that we'll talk about in a minute or two. So what is a meeting? Includes in-person gatherings, so whenever three or, in the case of a board like this of 5, whenever 3 or more are gathered together, that's a meeting. It includes communications to an intermediary. We'll talk about that in a minute. It includes emails. If you have a series of emails going for various members and you get to 3 or more, you're going to be back there. Facebook, same thing. Twitter, telephone conferences, all of those things can be meetings. So it's not just 5 people sitting in front of a group of folks in a notice public meeting. Any of these things can be meetings. Do I jump already? No. So, whom does the Brown Act apply? Let me go back a second. When is a gathering not a Brown Act meeting? One of the primary ones are social events, conferences, those kinds of things where people are there because there's, for example, a well is being dedicated and 5 members are there, but they're not making any decisions, they're not talking about any of the issues of the district. But even in a social gathering, if 3 members of a 5-member board go off in a corner and start discussing office business, that's a meeting, and it would have required a Brown Act. So generally, anytime board members are together discussing a matter, it's a meeting. If it's done through communications, emails, Facebook, Twitter, exchanges of letters, if people still use snail mail, that still could be a meeting. Who does it apply to? Local agencies, legislative bodies, persons elected to legislative bodies. It doesn't apply to staff. Staff can have a group of them can get together, but staff can cause a meeting. One of the ways we'll talk about in a second is the staff serving as the hub. The manager calls director number 1, gets their opinion, calls director number 2 and says, I talked to director number 1, and this is what they said, what do you think? then calls director number 3 and says, I talked to 1 and 2 and they think this, what do you think? They just had a meeting. The manager became the hub. The other way is the directors themselves do it, or the officials themselves do it. One calls the other, they reach an agreement, they call a third, talk about what the first 2 had talked about, we've had a meeting. And that's prohibited by the Brown Act without an agenda, notice, etc. So what is the legislative body? It's the governing body, the agency, obviously the board of directors in each of your cases. It's advisory committees, that is ad hoc groups of the board or of the agency. Standing committees, which are committees that are always meeting, and those can be less than a quorum. For example, Scotts Valley Water District has 2 or 3 or 4 standing committees of 2 members. But they meet every month and they discuss issues that are going to come before the board. Those have to be noticed just like a regular meeting. There has to be an agenda posted, there has to be public access to it. If public comes, they're entitled to public communication, oral communication. So all of those are the same thing. Temporary committees comprised of less than a quorum are generally not, if they're temporary, like one subject matter. Like, all right, 2 of you go out and take a look at something, tell us whether you think that tree needs to come down on such and such a site. That's not going to be a meeting when those 2 go out and do that, because it's a temporary committee for a single purpose. I talked about serial meetings before. This is the hub, spoke of the hub kind of thing. Consensus on an issue. Be careful of emails and other social media, public versus private devices. Up until 2 years ago, people thought that private devices, that is those of the officials of their own, were not subject to being discovered. Supreme Court of California has now said no, if they discuss public business on their private emails, then those are discoverable as well. So generally, most agencies now have, the members of the boards have their own business email with the district, which is discoverable, and their private is kept separate. And they don't discuss board business at all on those. So, types of meetings, the regular meeting, which is the one like we're having tonight, later tonight, as well as this one. You have to post an agenda 72 hours in advance. It has to be available, it has to be on your website. We can talk about the website in a minute. And the other type, special emergency meeting, that you have 24 hours in advance, or as soon as practical if an emergency applies. Generally, special meetings are for one subject matter. That's why you're having a special meeting. It's not like you have a general meeting and then you hold over 6 more items and have a special meeting and give a short notice. That's for a particular item, generally for an emergency. And then notice of adjournment posted within 24 hours, so you can't wait until the meeting and then call it off after everything's arrived. During a meeting, the public has a right to comment. There's some question in the state as to whether that right to comment is limited to the public comment portion, and that any public comment that is directed to particular actions being taken to the board all have to be addressed at that time, or whether individual comments need to be taken as each item comes up. Most districts, most boards that I've represented or been involved with allow comments on items as they come up, although they limit them in a reasonable manner, usually either 3 minutes or 2 minutes, depending on what happens. You have to have an agenda, has to have the location set forth, and the location has to be within the jurisdiction of the agency. I represented a small district down in San Benito County a couple of years ago, and they said, we're going to have a big meeting, we're going to have it over at the school. And I said, the school? They said, yeah, as you come into town, the school that's on the left-hand side. I said, is that in the district? And they said, no, but that's where we always have them. And those meetings are all invalid, because you have to have them within the district, unless it's a joint meeting of two agencies, that you can have it in either one. And you have to have access. Of course, people have to be able to get into the meeting. It can't be closed off. And there are special rules for teleconferencing, which this district uses quite often. That includes that it has to be on the agenda where that particular board member or board members are. The board member has to post a copy of the agenda at that location. So you may be in Timbuktu in a motel, but you have to have that posted outside. The door has to be open so that some member of the public can come in if they want. All votes when there's somebody teleconferencing have to be by roll call so that they can determine who said what, whereas in a normal kinds of motions, you can hear who says what, and so you don't need to. But when it's a teleconference, it has to all be by roll call. And I think I'm missing something.
There's quorum in place.
Quorum in place, that's the third one, thank you. Yeah, you still have to have a quorum in the district, in your jurisdiction. So if you had 3 of 5 members teleconferencing, you couldn't have a meeting. You have to have at least a majority of the district here, okay? Although there is an interesting sidelight to that for water districts, and that is, while 3 is a quorum, the requirement to pass a motion is that a majority of the board has to pass the motion. So if there's only 3 members present, you have to have all 3 voting in favor of whatever it is, or it doesn't pass. That's unique to county water districts, whereas in other cases you could get 2 out of 3. But in a county water district, even though you've got a quorum of 3, they still all have to agree because it's a requirement that it be a majority of the board to pass any matter. Closed sessions, they have to be expressly authorized. They're set forth in the Brown Act. They have to briefly be described in the agenda. And in the Brown Act, there is a safe harbor provision that's usually used, which describes the code section and generally what the subject matter is that's going to be talked about. You have to verbally announce the items. And if action is taken, this says may need to report to the public. My general practice is to recommend to boards that you always report out to the public. If an action is taken, what the action is, or if no action is taken, who was given instructions so that the public knows what happened. And the last line is for the members of the agency, and that is confidential discussions must remain confidential. There have actually been some lawsuits between agencies where somebody decided that even though their view wasn't upheld in a closed session, they were going to go out to the public and start rallying the troops. And a closed session is confidential. That's a violation of the Brown Act for someone to go out and start relating what happened in a confidential closed session. Common closed session issues are personnel issues, labor negotiations, pending litigation and liability claims, examination of witnesses during an investigation. That's typically comes up in labor matters where somebody's being terminated and they ask for a closed session hearing, or they don't even have to ask for it. It starts out that it is a closed session hearing. If they want to, they can have it be public. And on one occasion I've seen that happen, but usually it's closed session. Examination of witnesses during an investigation, real property transactions, negotiations. There is no general contract negotiation exemption. So other than real property, there is no exemption. The other exemption that comes up is that there is a claim or potential litigation. So if somebody writes a letter to the district and says, if you do this, I'm going to sue you, then the district has a right to have a closed session to discuss that potential claim of litigation. Ramifications for violation of the Brown Act. They can prevent it, be stopped by court order. Action not in compliance may be invalidated. Court costs, attorney's fees are recoverable. Person violating the Brown Act is guilty of a misdemeanor. That all sounds good. As of this date, no one has ever been convicted of a violation of the Brown Act in the state, to my knowledge, and that's been repeated, which is usually one of the big complaints of people who support the Brown Act. But the reality is what happens, and I've seen this happen a couple of times, is the DA is consulted. The DA contacts the district or the agency and says, you know, there's a claim here that there's a violation of the Brown Act in what you did. And the district takes a look at that and says, well, fine, let's put it back on the agenda. We'll do it in an open session and we'll ignore what happened before. And so it does work, but it doesn't work necessarily in a conviction of a misdemeanor. Mentioned email earlier, but this is has been a big problem because it's so easy to hit the reply all button. When you're dealing with district business, refrain from ever using that button. I have the problem of refraining to the point where somebody said, well, you didn't tell me that. I was like, yeah, because I only answered back to the person that talked to me. Never take a position or make a commitment on email. Email board for info only and public versus private devices. I mentioned earlier the Supreme Court decision. Okay, conducting public business, the Public Records Act. Let me back up for a second because I mentioned Brown Act agenda requirements. You should all be aware that AB 2257, effective January 2019, puts in a bunch of requirements for agendas. They talk about online posting of agendas, and that you have to have a link to the current agenda directly on your home page. And the link has to be direct. It can't be a series of clicks to get to it. It has to be right there. The agenda has to be retrievable, downloadable, indexable, and electronically searchable, which sounds to me like French or Greek, neither language of which I speak. But what it means is you can't add Word docs to your agenda because Word is not searchable by all search engines. It has to be a PDF. And so you have to export your agenda to the PDF. So there's a bunch of requirements that are all required now under that act, and should make sure that your staff is aware of that and is meeting that. Now, California Public Records Act. What did I do now? You did. I'm probably going to take 15 minutes. This is something put out by the League of California Cities, only on the Public Records Act, about 3/4 of an inch thick. So the real issue is if you get a Public Records Act request, talk to your legal counsel, make sure that you're following the rules and that you know what the requirements are. Every person has a right to inspect public records of any state or local agency in California and in most states. And it's any writing containing information relating to the conduct of the public business. That's very general and doesn't really tell you much. But it does include any form of recorded communication, including paper, electronically stored information, tapes, CDs, photographs, electronic documents, any forms, flash drives, etc. Anything that has information is discoverable under the Public Records Act. Public agencies must make disclosable records promptly available. 10 days to respond to the initial request, and you can ask for a time extension of 14 days for unusual circumstances. Once in a while, you have to ask for a longer extension. And one of those usually occurs because there's a request that includes searching a lot of data or a lot of emails or something of that sort, which takes a lot of time. And I know recently this district did that, And then after they got the search back, they realized it was incomplete. So rather than furnish an incomplete record, they asked for a further extension to furnish the complete record. But what you've got to try to do is do it as promptly and as reasonably as you can, given the circumstances. So what public record are exempt from disclosure? They're all statutory. Preliminary drafts, notes, or memos not kept in the ordinary course of business, and there's a balancing test that we can talk about in a second. Real estate appraisals, personnel, medical, similar files, virtually all personnel files are not discoverable under the Public Records Act. Records about pending litigation, arrest records, complaints, investigative security file, taxpayer information, certain utility information such as customers' names, addresses, utility uses. Although during the drought, some agencies put out names of people who used a lot of water, and they did that under the theory that their particular agency had a policy of discouraging high uses of water, specific policy, and they did that. There was some controversy throughout the state as to whether that violated the Public Records Act exemption or not, but that's one of the areas where that happened. And then the catch-all exemption in 6255A, which says that public interest in non-disclosure outweighs the public interest in disclosure. You have to put that in writing, and it's a heavy burden. The burden is on the agency to prove that that's true. So the best practices, always respond to them promptly, to the extent you can. Consider adopting regulations for responding. The third is important: adopt and follow a records retention policy. Not after you get the request, but long before. How long you're going to keep records, when are you going to destroy records, and then you follow it. There have been a couple of agencies in response to public records requests decided, oh, we don't want to keep these records that some they're asking, and they destroyed them, and that gets you into big trouble. You have to follow your own records retention policy, and then you're not accused of doing something to defeat the Public Records Act. We talked about not using your personal email account for official business. You have a standard fee for copying program and computer services. Copying services are basically 10 cents or 15 cents or whatever it is per page. The programming services are often third-party services. You may have an IT service and they will tell you, this is how much an hour we charge to do a search. That's whatever it is, that's what it is. And then clearly document the steps you took to identify responsive documents. Because if somebody brings in a case against you and says, I asked for it and they didn't give it to me, you want to show we went through these steps to make sure we gave them everything that they were entitled to. Due process. Due process comes from the U.S. Constitution, Article 14, Section 1, private people of life, liberty, or property without due process. That's incorporated in the California Constitution. So what does due process require? Notice, opportunity to be heard, which is due process procedurally, and fair and impartial decision makers. That comes up in employee termination, where we have a whole series of procedures called the Skelly system, in which you have hearings and a right to appeal and a further right to appeal and finally a final decision, which sometimes is usually made by the legislative agency, the board, although on occasion I recommended, and we've done this, where we've used a third party, like a retired judge, for total impartiality in the final appeal, so that there's no question that they're getting a fair shake. They're not getting something that's slanted one way or the other. Bias, of course, is related to due process. You could have financial bias in making a decision. You could have personal bias. against people and ideologies, and you have factual bias. The ultimate issue is, can the decision maker decide the matter on appropriate grounds? So, we'll talk more about bias, but some of it's pretty clear. You know, if you're on a board and you're trying to decide whether a bridge should go over a particular area, and you happen to be also a person who has an interest in some land that's going to get served by that bridge, which is pretty useless without it, but now would be valuable, you have both a financial interest and you've got a bias. You want it. And that sounds pretty far-fetched. And a city councilman in Fremont some years back had exactly that bias, voted on it, and ended up losing his job and being prosecuted for it. So it's sort of common sense, but sometimes dollars get in the way of common sense. So if it seems like there's any kind of bias, just avoid it. Avoid the decision. Competitive bidding. Okay, public bidding. General rule is that no competitive bidding is required unless specifically required by statute, a local rule, or policy. Now, county water districts, of which a number of you are associated with, are not required to have competitive bidding under the public contract code. It's very strange. A water resource agency is, an irrigation district is, but there's kind of a series of them. And county water district doesn't appear. You know, for Mr. Harmon, fire districts do. So they're required to do competitive bidding. And as John Ricker knows, the county has to do competitive bidding. It just so happens that county water districts are not required so. But in any event, if you do bidding, it's the lowest responsible bidder, and there are exceptions when you don't have to do that. But I don't know of any district, none that I've ever represented, that doesn't do competitive bidding on substantial contracts, because it's one of perception. It's what it looks like to the public. That if you don't put it out for competitive bidding, you're somehow favoring somebody, or you may not be getting the best price for the public. So almost all agencies do it. But there are exceptions. There are times, for example, recently, in the last year, when there have been very few contractors available to get jobs done. And a job needs to get done, and it needs to be completed. Paving has to be done to finish the project so you can get it closed. And under that circumstances, county water district's perfectly able to say, that's fine. We're going to find whoever we can get and do it. We know they did a good job, and there's not a violation. So you should check your own agencies and enabling statute. But I know that the county water districts is not subject to public contract code. Okay. Avoid missteps, appearance of bias or actual bias, financial interest in the decision. We'll talk about that in a minute. Personal interests that alter your decision making. Statement that your mind's made up, relying on evidence presented outside the record. So, best practice. Think fairness, merit-based decisions, not personal relationships. So, it sounds easy, sometimes it's not easy. Years ago, I proved Mark Twain's comment correct that God created idiots and then he created school boards to serve on them, and I served on one for 5 years. And in the middle of it, we had some controversy, and standing in front of the group opposing what we were about to do was close personal friends of ours, whom we belonged to a gourmet group with and met every month with, etc. And they're taking the opposite position. It's not easy to look those friends in the eye and say, I'm sorry, I understand what you're saying, but my job, along with the other board members, is to reach a decision that I think is fair and right, and that's what you got to do. So you got to forget about personal relationships, as hard as that is sometimes. Listen during public meetings, keep an open mind, be prepared, read the materials submitted. And I'll talk in a minute about this, but the other thing is avoid avoid taking positions ahead of a meeting. And in smaller communities, it's not easy to do that. When I was on the school board, I used to get calls, 6, 7 calls before every board meeting with somebody telling me their position, which I would listen to. But my answer always had to be, I'm only one member of a 5-member board. I have to listen to everybody else and then reach my decision. Because otherwise, they think they've got you committed and then you don't do what they want. You know, then I think you're someone they can't trust at all. But your job is to be a member of that group and make that decision with that group. Okay, avoiding conflicts of interest. Government Code 1099 says, limits how many public offices officials may handle. And if the duties of 2 offices clash, then one serves at the pleasure of the other. So what happens? Example of fire chief and city council member, but there's even easier ones than that. 10 years ago, somebody came to one of the water districts, and he was on the fire district within that water district. And I said, you know, if you get elected or appointed to the water district, you're immediately off the fire district. And he said, oh, no, that's not true. I talked to my attorney. I said, you better talk to your attorney again, because that's what the doctrine of incompatible offices does. 4 years ago in Aromas, one of the board members who knew about the doctrine ran for the school district, and the school district is a customer of the water district, and there's always issues of fire flow and testing and all this. But when she was elected to the school district, her seat on the water district immediately became open. And sometimes it's tenuous. Years ago, Gary Hazelton, who was in the assessor's office, but not at the time the assessor, was a member of this board, the Soquel board, for a long time. Gary ran for the office of assessor, and he realized that he would have a conflict. There would be incompatible offices, because while the water district doesn't pay property tax on anything within its jurisdiction, it does pay property tax on property outside its jurisdiction. And under the law, the assessor, county assessor, is the ultimate decider of what valuations are on property and what the taxes should be. So he resigned from the water district before he completed running for the assessor. So you have to kind of watch those things. Incompatible activities prohibits local officers and employees from engaging in activities that are incompatible with positions of officials. That rarely happens. Each agency may adopt rules or incompatible activity statements to implement that provision. And again, I have never seen that happen. The revolving door restrictions came in fairly recently. Applies to elected officials and top managers. They're prohibited from making, participating in, or using their official position to influence the making of governmental decisions affecting a potential employer. And that's a 1-year ban. Local agencies can adopt more restrictive rules, although I don't know of any that have. Political Reform Act. All public officials and agency management employees fill out Form 700 every year. And in addition to that, every time somebody takes office, they have to fill it out. Every time they leave office, they have to fill it out. And the forms have become a little more complex over the year. The filers are listed in the government code section, but in addition, each agency lists their own additional people. You have a requirement of full disclosure, but only within your own jurisdiction. So for example, I live in the city of Santa Cruz, so for my Form 700, I don't have to list any property I own in the city of Santa Cruz for Soquel Creek. for a while, I owned property in Scotts Valley, so in my 700 for Soquel, I didn't list that. But in my 700 for Scotts Valley Water District, I had to list that. So you, by jurisdiction. So that, you gotta be careful to make sure that it fulfills the requirements of the Form 700. There's a requirement of full disclosure. And that's the form. Income management, business management, real property, firm, personal finances, and gifts.
It's coming up, right?
Yeah, it's coming up double. Oh, I see, it's coming
No,
up.
no, I meant the form.
Yeah, I see. Got it. All right, so all that has to be listed. And you can't participate in the decision if you have a direct or indirect financial interest. So these are the 4 questions they suggest you ask. Will you be participating in the decision? Does the decision affect your economic interest? Is the effect of the decision on your economic interest material? And does it affect your economic interest differently than the public generally? So let's talk about that. Let's suppose you live in the Scotts Valley Water District and they're going to put a new main up your street that'll go for 700 yards and affect 30 different people. Can you as a member, if it's on your street, vote in that one? I think you clearly can. Because it's not material to you any more than it is to that many other people. But if she doesn't mind, I'd like to use Ruth's example. Ruth called Ruth's house in Scotts Valley Water District called one day. And her question was, in the capital budget, there is a remodeling and redoing of a pump station. And the pump station is near me. And I said, how near? And she said, next door. And that it would reduce the amount of noise if they did that. Is that something that affects me more materially than anyone else? And we kind of concluded that it did. And so whenever that subject matter came up, even though it was part of the capital budget, Ruth got up, left the room. Didn't participate from the audience, didn't participate from the stand. Because that's what you have to do. If you've got something that's more directed at you, it has a stronger effect on you personally than it does the public generally, then you have to withdraw. Now on another question, we had a couple of members of the Soquel district, a couple of the board members who were stockbrokers. And they were stockbrokers for what is now, I think, Morgan Stanley. I think this week it's Morgan Stanley. And the question was, since their compensation is based in part on how well Morgan Stanley does, and Morgan Stanley is one of the bidders on Soquel Creek water bonds, does that constitute a conflict? Because if they go for bonds and they get awarded Morgan Stanley, it means more money. So we got an opinion from the Fair Political Practices Commission on that one, and they concluded, no, that's too remote. That's not going to be a conflict. But you can see, you can find one almost anywhere if you look. I have to say, in all honesty though, the Fair Political Practices Commission doesn't always respond well to those requests. They have a policy of responding within 21 days, but often around the 21st day they say, well, we can't really give you an answer to that. We have to get more detail and it has to get closer to the real problem. So what do? You do what Ruth did. You don't participate in the decision, you don't participate in the discussion, you don't give any advice, you disclose it, and you disqualify yourself, and the best thing is walk out of the room. So that nobody takes the position, well, you know, they aren't going to vote against it because she's still sitting there, he's still looking at him, etc. So, personal financial interests, particularly important relative to rate making. I mean, generally, rate making applies to everybody in the community. It's not a problem. There are some agencies, however, for example, some water agencies where they may have only one large irrigation supply customer. And if that person is represented on the district and it's a rate that would only apply to that person or two people, then they might have to disqualify themselves for bias because it would affect them personally. And if they don't, you have the potential of invalidation of a decision, misdemeanor or felony perjury, loss of office, fines, attorney's fees, and I think among the worst, loss of public trust. Interest in a public contract. This one, Government Code 1090, is difficult because it says you shall not be financially interested in any contract made by them in their official capacity or by any body or board of which they're members. Some years ago, the Aromas Water District was in bankruptcy, just about the time I became their attorney. And they couldn't borrow money from the bank. They were in bankruptcy, they had no money. And one of the board members said, I think they needed like $6,000 to do something. And she said, look, the bank's paying me in those days, I think 3% interest. I'll just give you the money and you just give me whatever the bank was. So here she's taking a secured FDIC insured savings account and giving it to the district in exchange for the district who's in bankruptcy promising to pay her 3%. And they called me up, I said, you can't do it. 1090 makes that a felony. You cannot have a contract between a district member, board member, and the agency, or any body of which they're members, period.
Even if they don't take part in the decision.
Even if they don't take part in the decision.
It has nothing to do with it.
I think so. Now, we had another one of those recently in San Lorenzo Valley, where a board member convinced, I don't know what convinced, the suggestion was made that the district was doing a tank replacement, that acquisition of a piece of property alongside of that tank would be useful for setup and whatnot, and probably was. The problem is that the board member was the realtor and his wife was the agent, and he voted on it and got a commission. She got the commission. An action was brought in Santa Cruz Superior Court, and it was found to be a violation of 1090, as well as the FEPC, the Fair Political Practices Act. That went on appeal and was sustained. And the San Lorenzo Valley Water District at one point had paid something like $140,000 in attorney's fees for their own attorney and for the attorney on the other side, because there was an award made. So these are not matters to take lightly. If it looks like there's any potential of a conflict, just avoid it. Yeah, and it applies to everything. Preliminary discussions, negotiations, bid solicitation, it doesn't make any difference. You can't, say, well, no, I just brought it to their attention and I made a big deal out of it and then backed away. You've got to be aware of it all. Disclosure doesn't cure the conflict, as Director Daniels pointed out. Disqualification is not allowed for members of the governing board. Employees and staff can disqualify. So if you've got a staff member who happens to own a piece of property and the district's interested, the staff member can back away from it entirely, but you can't for a board member. And then direct and indirect interest. Yeah. Okay, there are some statutory remote interests, statutory non-interest, narrow rule of necessity. The narrow rule of necessity is the only one that usually comes into being, and that's when this is the only, for example, this is the only place where they say there's water to drill a well in the whole entity. And so all the experts say if you don't put it on that piece of property, you're not gonna get any water. But again, the member who happens to be on the board should completely disqualify themselves from that. And I would still get a decision from FVPC or somebody that says, yeah, okay, you meet the rule of necessity. Because you don't want to find out later you didn't, since it's a felony. And the contract's void, felony conviction, you have to pay restitution and barred from public office. This is just a comparison of all of them, of the two differences, the Political Reform Act and 1090. 1090 is far worse. Violations of 1090 are fortunately few and far between, but the fellow in San Lorenzo Valley was convicted of 1090. Bribery, we shouldn't have to spend too much time on that. But this is giving a public official any kind of benefit to influence his or her vote. Crime is complete once an offer is made. Doesn't require specific words or behavior as long as the circumstances show it. There can be benefits received in the future, could still be it. You give Super Bowl tickets for next year is their example. Penalty 2 to 4 years in state prison. And I suppose maybe because I've grown up here and a California person, but I always thought this was, why do you even have to tell somebody this? But about 30 years ago, I was representing a developer in Santa Cruz who was trying to put together a project. And he said to me, he was from New Jersey. He said, how much is the filing fee? And I said, it's probably about $1,200 for the permit. And he said, well, yeah, but how much is the filing fee? And I said, it's $1,200. He said, that's all? I said, yeah. He said, in New Jersey, there's 2 fees. There's the permit fee, and there's the filing fee that you have to have in a white envelope that you slip underneath the counter. And he said, that's usually 4 times or 5 times the filing fee. So, things are different. At least, I don't know of any filing fees ever being paid in California. At least not here. Now, maybe in Bell, California, that might happen. All right, campaign contributions. So, covered officials are prohibited from receiving solicited campaigns, $250 from parties or other financially interested persons during the pendency of the proceeding for 3 years after its conclusion. That's generally what they're talking about, is somebody making a campaign contribution while there's a matter pending in front of the board, so that you're kind of influencing the board, and anybody who's received it in 12 calendar months prior to the matter being submitted has to disqualify themselves. Gifts. And this was just raised in January. It was $470 for the last 5 years. We've now decided to raise it up to $500 as of January of 2019. So gift limit of $500 per source per year. So what you end up having to do is anytime you get a gift of $50 or more, worth $50 or more from any source, you have to keep track of it. And if it's more than $500, that's the ultimate limit. So you have to disclose the 50, but above 500, you can't accept any more. And if you do, if you get another gift, then you have to immediately return it or contribute it to charity or something to show that you're not taking it. Applies to elected, how do I do that? Yeah, elected officials, appointed members of the government, candidates for office, anything of value that provides a personal benefit for which adequate consideration, and the exceptions are things like family gifts, wedding gifts, birthday gifts, those kinds of things are not included in that category. As far as gifts, you have to estimate the value, track them, as I said, to $50 at a shot. And then if it exceeds $500, then within 30 days you have to refuse it, return it, or donate it. One of the three. Exemptions are gift to public agency, that is, some gift was to the agency itself. Gifts returned unused or donor reimbursed within 30 days. Gifts from family members, gifts of hospitality, equal value gifts, except gifts to hospitality require that you and the person who's extending the hospitality have to be there. In other words, somebody can't give you a gift of 2 weeks at their cabin in Tahoe and they're not there. That's a gift, so you have to value what that's worth. But if they invite you to their cabin in Tahoe and they're there, then that's a hospitality item and you don't have to report it. Not reportable gifts, if the agency controls the use of the payment, if it's used for official business, used for travel expenses, it has to be consistent with the agency's expense policy, but then the agency has to file a Form 801. And I don't think any of the agencies, none that I represent bother to even do that. I mean, it's rather than take a gift. And I'm assuming what they're talking about is maybe a gift of a travel of some sort, or a gift of having somebody go to something, because there are special rules that apply to tickets, like game tickets. There it is. Third-party tickets usually performs a ceremonial role or function on the agency behalf. So if somebody gives you a ticket, a board member a ticket for the board to appear, board president for example, to appear at some entity to present an award to someone, then that's exempt. But if it's just a ticket so that the board member can go and watch the football game or go to the symphony or whatever, that's a gift that's not exempt. And then if the agency gets tickets to anything, typically sporting events or something of that sort, they have to have a written policy, and then again, they have to file a Form 802 with the FVPC. So it's probably not worth it, in my opinion, for an agency to even begin to accept those kinds of things. Certainly not the size of agencies we're dealing with here. And then gifts from an agency to official. Agency payment of food, beverages, entertainment of more than a nominal value, reportable gifts, unless they're a lawful expenditure of public funds, for example, budgeted staff functions or holiday celebrations, refreshments at an agency meeting, typically when water districts have to meet for unusual hours and over the dinner hours, they may provide some kind of food for the entity, but they're not talking about anything other than that. Years ago, the Santa Cruz City Council used to have a meeting in the afternoon, break for 3 hours, and go to a very nice restaurant and have a dinner at public expense, and then go back for their afternoon meeting, but they don't do that anymore. They haven't done that since the FPBC sort of started looking at these things. Because the result is you could have the Fair Political Practices Commission can file civil action, penalty of 3 times the amount of the gift, $5,000 fine, 6 months jail, bribery, extortion. Not worth it. Okay. Honoraria, these are payments for speeches, articles, attendance at events, and basically you can't do it. There are a few exceptions, but not many. And again, if this comes up, talk to your counsel. Travel and lodging. This can't be provided either by third parties. It applies to all the legislative members. And the exceptions are, if there's exceptions for education, again, This is the FPPC's whole 10-page small print sheet on the exceptions for travel, lodging, and honoraria. So if there's a question, ask your counsel to check it out. Reimbursements, what does it cover? There's things that are expended on behalf of the agency. Typically, travel, when somebody travels to do a convention or something of that sort, you get reimbursed. Can be anything associated with agency business. And they require, most agencies report those on a monthly or tri-monthly basis, so that they're out there. Loans. Elected officials may not receive a personal loan from any officer, employee, member, consultant of the official agency while in office. So can't get it from employee, can't get it from consultants, etc. And you can't get loans of $500 or more unless they're in writing, and the writing clearly states the term of the loan, the parties, date, amount, term, interest rate, amount of payments. So that's from anybody. And the reason, of course, is that without some kind of documentation, that loan could suddenly become a gift. I mean, where somebody discovers the payment was made, and then they say, oh, no, well, that $10,000 was a loan. It's a loan. We talked about it, and I promised to pay it back. This says you can't do that, that you only can do it if you've actually got it in writing and it's clear. The exceptions, of course, are family. You know, if you're loaning money to your kids or borrowing money from your dad or mom or aunt or uncle, if you're that lucky, then there's an exception. Misuse of public funds. California law prohibits public officials, now these aren't only board members, these are all public officials, for using public resources for personal purposes. Penal Code 424, Penal Code, so we're talking crime again, right? Public funds include money, equipment, supplies, compensated staff time, use of telephones, computers, fax machines, which is not to say that when you're in the office and you call home to find out what time you're supposed to be there for dinner, that's going to be a violation. But if you decide to run your campaign from the district office and you're running a phone bank, then it's a violation. Some of this you'd say, well, everybody knows you can't use public money for your own benefit. Many, many years ago, the city manager of Capitola used a credit card, a company credit card, the city credit card, to buy a set of golf clubs at the Delavia Golf Club, and to buy lumber for a deck at his house, which he didn't reimburse. The district attorney brought an action under Penal Code 424. He went to a preliminary hearing, pled guilty, and it was only because of a great outpouring of letters from the community to the Superior Court judge that we kept him out of going to jail. But he was put on probation for like 4 years, and even though he'd always been a public servant, he never could hold any kind of office in a public agency again. So this is serious stuff. Misuse of public funds can be very bad. Now, mass mailings. Mass mailing of public expense by public officials is prohibited because it's unfair to use public resources to enhance visibility. So that means that in your newsletters, you can't have columns by members of the board of directors. You can't use mass mailings about members of the board of directors because it's prohibited. But it only is prohibited for mailings. So it's not a prohibition against emails or blogs or email blasts or anything of that sort. So if there's an email newsletter or an email release that goes out and it wants to have a comment by the chairman of the board or a different director every month, or the manager or whatever, that's totally permitted. It's only mass mailings, and that hasn't been changed. Misuse of public funds, this is what we were worried about in the case of city manager, 4 years in prison, $5,000 violation. There were no attorney's fees because he paid his own attorney's fees, but the opposing party was the district attorney. But he was barred from holding public office ever after. So, in conclusion, much quicker than I thought, but I'll take questions. These are the areas: political financial interest, the Reform Act, contracts, bribery, personal advantages and perks, gifts, honoraria, travel, lodging expense, loans, reimbursements, misuse of public funds, Brown Act, public records, due process, competitive bidding, bias, incompatible office, incompatible activities, revolving doors. Here's some guidelines, but call me, I'll give those to you. So, members that are here for ethics training, questions? Yes.
What I wanted to mention is when you're filling out the Form 700, you don't have to disclose investments in mutual funds. So over the years, I've moved things from individual stocks, individual bonds, into mutual funds, and then you don't have to list everything you own.
That's right, that's right. And you also don't have to list specifically the number of shares you have, for example, in IRAs. If they're invested in different things, you can simply show what they are so that they know you're invested in whatever or something or other, but not necessarily how many shares of that you have. And in the case of attorneys, we're not required to list our clients in terms for income purposes, because that's a disclosure of how much they happen to pay or whatever. No other questions? Clear as mud? Yes.
Form 700, when you re-up it, if everything's the same, is there a place on there where you just sort of check something?
There is now.
Yeah.
It's on the form. There's no change.
Yeah.
Originally, you had to fill them out every year, the whole thing, but now there's been no change.
There's also an electronic version.
There's electronic. Santa Cruz County has electronic versions. Monterey County has electronic versions. San Benito does not. Yes, sir.
The meetings, like the meals that are offered to us at an ACWA conference by the various suppliers and such, are those accepted on the hospitality if the...
That's a gift, which is always fun because you're trying to figure out how much did this cost? You know, 'cause they're asking you and they put it out there, so you just have to be.
Yeah, I'll add, a lot of the good firms will send you a quote for that, you know, about take the total cost of the item.
Can't have another glass of wine because that would put me over.
Well, only if it doesn't put you over 500.
Oh, right.
Right?
But
You
even
just
if
have to
it puts you
report
over,
it if it's over 50.
you have to disclose it if it's over.
Yeah, so most of them are 49.
Yeah.
That would be the usual guess, is somewhere around 48, 49. Yes, Becky?
What's the policy regarding a member of a board making a political endorsement of a fellow board member or someone related on the same type of board?
On the same way?
On a related board, say Soquel Creek Water District getting an endorsement from a member of the Mid-County Groundwater Agency Board. Is that, what would you have to say about the ethics of that?
I don't know if that even comes up. I mean, that's, you know, everybody's entitled to participate in the political process.
And to register your endorsement as a member of that board, rather than a person?
On most occasions, I think if you look at most of the endorsements I've seen, they say that that's for identification only. I mean, you simply see titles listed for identification only. So it's not that the board is in, of whatever they're on is endorsing, but just who that person happens to be. I mean, I still get listed for Santa Cruz School Board member. I haven't been on there since 1985, so I don't think anybody's putting too much weight on that.
Thank you.
Hey, you good?
I think we're good.
All right.
Thank you, everyone.
So just as a reminder, thank you everyone for coming. So we're gonna have a closed session from 7 to 7:45, and then at 7:45 we'll have the regular meeting.
Do you want to talk about the certificates? Are we
Yeah.
going to be sending those out?
Yeah,
We have a
actually,
list, so if did everyone sign the sign-in sheet? Okay, I just wanted to make sure in case we have.
So you'll send that electronic?
yeah, I can sign it now,
Do you
sure.
want to do it tonight or send in whatever's
If
easy?
you-
Yeah, we'll get them out.
If you weren't on the list, we'll mail them to you. Why don't we just mail them? I think we have everybody's address.